Hi everyone. Today I'm going to be talking about the pet laws that are coming into place from March 2nd and provide a little bit more information for you in regards to the details of this new law. So we're going to start with what is classified as a pet. So under Consumer Affairs Law, a pet is any animal that is not an assistance dog. So a renter now can request a pet by submitting the Consumer Affairs form, and the renter's owner has 14 days to respond to that request. And if you don't respond to that request within 14 days, it is deemed that you have approved that pet. If you do want to object to the pet, the only way that you can object is by putting in an application to VCAT, and then a judge will hear the details of the pet and the property and decide if it is reasonable to object to that request. VCAT are very pro-tenant, always have been, and they are also very inconsistent with their rulings. So it can really depend on the day, what member you get, what mood they're in, and highly recommend having a professional attend on your behalf, because there is a certain process involved, and presenting your case is vital to getting the best outcome. Important to note for this reform is that any council laws or body corporate policies overrule the Consumer Affairs Law. So if your body corporate has a pet policy in place, say no pets, then you are covered and you can use that as an objection. If a tenant requests a pet, can you request a pet bond? The answer is no. You can't request a pet bond, but if you have a tenant that does request a pet, I highly recommend doing an inspection of the property, because you want proof of the condition of the property prior to the pet. In case there is any damage caused, you need to be able to provide that proof. In saying that, you can only inspect a property twice a year. It's also important to note that you can't put a clause into your lease stating that there's no pets allowed on the property. Agents have many clauses in their residential tenancies agreements that are not part of the Residential Tenancies Act as such, but if both parties have agreed to them by signing of the lease, then they are enforceable. A good example of this is a steam cleaning for a property. So all agents have a clause in their lease agreement that state the tenant must steam clean the carpets when they vacate. This is enforced in VCAT by most judges. Some don't, but because both parties have agreed to it, it does hold up. But this is not going to be the case in regards to the pet reform. If you're a private owner and you have a problematic tenancy, or would like advice on the 120 reforms that are about to come into effect, please contact me, property@nataliegrant.net. Head to my website, nataliegrant.net. You'll find there all the landlord services, including my brand new range of leasing services. Just take this shot.